Hello and welcome once again to Minds That Matter. I'm your host, James Thomas, and we have a very special guest today. We have retired Judge Stephen Erickson.
It's great
to have you here, Judge.
It's great to be here.
Great. And in our little bit of talking before the show, I found out you're in fact not retired at all.
Oh, I'm a retired judge.
You're a retired judge, but you've repositioned yourself
exactly
quite well.
Right.
What I wanted to start off the show with was to just find out sort of your history.
All right.
What got you into law? What brought you to becoming a judge? And then what you'd been doing in terms of some of the problems that you saw related to behavioral health issues, mental illness, and the criminal justice system.
So that'll be the first 2 hours?
That'll be the first 2 hours,
okay.
Yes.
Well, I'm a Rhode Island native, live in Middletown, the same town I grew up in, and went to public schools here in Rhode Island, Middletown High School, University of Rhode Island, went to Boston University Law School, graduated in '76, came back to Rhode Island, came back to Newport, practiced law in Newport for a number of years. I was a state representative for 8 years, representing Middletown and Portsmouth. Then I spent 4 years working in the governor's office, doing legislation and appointments and various other matters. And then at the end of that, I was appointed to the district court, where I served for 20 years, retired last July 30th after 20 years of service. And since then, I've been active in a number of different activities, as you said, repositioning myself. I suppose that when you're a lawyer, and I'd always thought about law as a career I wanted to go into. I'm one of those people that went right to law school after college. You always think about the possibility of being a judge. I have to say that when I became a judge, I was fairly young. I was 39. And you don't really know for sure what it's going to be like. And I have to tell you that it wasn't anything like what I thought it was going to be like. I enjoyed 20 years on the bench. They were tremendous. They were wonderful years. It was very different from what I thought it would be. And part of what made it different was that I don't think that anybody going into the system, even those people who practiced in the courts, as I did before I became a judge, really understands the scope of the problems that the courts face with respect to behavioral health issues, mental health issues, and substance abuse issues, which probably in one way or another, when you add up the drunk driving cases and the domestic assault cases and some of the shoplifting cases and so forth, probably substance abuse, mental health issues impact 80% of the cases that we see on a daily basis on the criminal calendar. And so over time, you become aware of the fact that there's something going wrong in the system, that the system isn't responding correctly, that the system hasn't adapted to the environment that exists in the courtrooms.
Okay.
And so I became very interested in trying to make those changes within the system to get the courts to redirect their attention toward the nature of the population that the courts were now dealing with.
Okay.
And that's how I got involved in it.
Well, we had talked again before the show about, I've been working in Rhode Island for, 30 years now, working in mental health. And that was in sort of the kind of midstream deinstitutionalization notion of having the mentally ill leave Eleanor Slater Hospital, or what we used to call the IMH, and get out into the community and integrate in the community.
Yes.
And then I realized, maybe 10 years ago, that we really had created trans-institutionalization, where a lot of the folks that had been mentally ill who left Eleanor Slater Hospital, the IMH, ended up at the ACI, ended up at the intake center. And it seems that was part of what was wrong, that the system was not meeting the needs of folks that were mentally ill. Would that be fair to say?
I think that's fair to say. I've said before, and I think it's fair to say still, that we didn't build any new buildings in Cranston, we just moved the fences. Now, we did build some new buildings, but we also moved the fences. We took a large number of people that were previously institutionalized on the psychiatric side, and now many of those same people, or people with the same types of difficulties that those people had, will now find themselves inside the fence at the prison. And That's true for a couple of reasons. The first is that, as we know, when deinstitutionalization took place, the population was substantially reduced inside the facilities. The community mental health centers and the local providers were supposed to have the resources to provide a full spectrum of services to those individuals. And although Rhode Island has done very well in that respect in comparison to many other states, we still do not have the scope of resources, the scope of programs available to people that we really contemplated as being a necessary alternative to institutionalization. So you have a lot of people that have behavioral health issues that are in the community doing things that if they were in an institutional environment would be seen as part of their illness, but when they come outside and do those same behaviors, engage in the same activities, they're now seen as criminals. And so they get put into the category of criminal because they've done an act which we define as being a criminal act. And so then it's very easy to solve how you're going to take care of them. You bring them to court, you give them an attorney, you conduct a trial or you take a plea, and then you sentence them to either probation or a suspended sentence, or on multiple occasions, if a person's been before the court on multiple occasions, you might put them in jail. So they wind up being treated as if they didn't have those problems, but were simply criminal. What I said was that what we needed to do was to move away from that paradigm to a new paradigm that understood what it is we were dealing with the people that were in front of us. We weren't creating excuses for people, but we were getting explanations for behavior. Because as somebody once said, the definition of insanity is to repeat the same act over and over again, expecting a different result. And if we continuously said, this person's mentally ill, let's put them in jail, that'll make them stop doing these acts, obviously we were missing the connection between the explanation for the behavior, which is different from somebody who is what we traditionally consider to be a criminal, and somebody who's mentally ill. The motivation for the act is entirely different. And so the court's response needs to be different in order to be fair, to be just.
Now, you were one who was seen by providers of the mental health community as a champion for the rights of the mentally ill in the judicial system, I believe, and I've heard that from many other folks, and that you were a judge who would look at, if possible, if appropriate, diversion from intake or the ACI to a treatment facility in order to help that person recover, get their needs met and related to their mental illness. Now, but that's not a pervasive way of looking at being a judge, is it?
Well, things go through cycles. And the purpose of punishment is one of those things that you look at it from an academic perspective, goes through cycles. Why do we send people to jail? To punish them? To incapacitate them? To deter them from doing the same act again? To deter other people from doing similar acts? Those are all or to treat them. Those are all at one time or another considered to be the predominant reason that you put people in jail. And the reality is that for each person, it may be a different reason. For somebody who's a career shoplifter, going to jail is a cost of doing business. For a mentally ill person who has a fetish about one particular item that they take out of a store, going to jail does nothing. So it's not so much changing what we're doing as recognizing the variety of circumstances that we have in front of us as a court. And yes, courts are very slow to change. We still wear black robes. We've worn black robes for hundreds of years for no good reason. Why are they black? Why aren't they red? In England, judges wear red robes. Why do we wear black? Nobody quite knows for sure why these things happen. We still cite precedents that date from the 1300s as being good law, because they are. Courts have a strong institutional desire for continuity and slow growth. The problem is our society recently has gone through such fundamental changes, and we have made such major changes in, for example, the area of behavioral health, in how we treat people, that the courts have not caught up with fully the nature of the changed society. So courts do have a responsibility, in my opinion, to adapt to the society in which they find themselves. And part of that process involves understanding and reacting to the flood of mentally ill individuals, the behavioral health problems that we have facing the courts. Because we're not doing society justice if we don't address the issues that cause people to come before the court. We're simply taking them out of circulation for a while and then having the same problems repeat themselves.
Now, we talked a bit, again, before the show about the forensic unit.
Right.
Where folks that are deemed as potentially mentally ill, maybe when they come before the judge, go for a competency evaluation, and depending on what they may have done, get sent to Eleanor Slater Hospital's forensic
Yes.
unit for competency evaluations.
Right.
That's only a 20-bed facility for the men. And with women, there's very few women, and they go, I think, to one of the general
Right.
wards of Eleanor Slater and go through the process. That seems to be significantly inefficient or ineffective in terms of the numbers of people that probably could benefit from forensic evals and or forensic treatment if they committed a crime as someone who was mentally ill.
Well, again, we have systems, we have structures, we have procedures that have not fully adapted to the current environment. Those of us who have been to the forensic unit know that the conditions there are terrible. The physical environment in which people find themselves is not appropriate. It's just wrong. Yet to try and find the money to create an alternative to that has been a very difficult task. There's now progress in that direction. I think the department is making some substantial improvements in that respect, and they have a plan to move that facility into the general hospital and to create an environment that's more appropriate, more conducive to treatment. And we have people who wind up going there for relatively minor crimes. If we don't have adequate outpatient competency restoration procedures in place, they wind up staying there, even though they've been charged with a relatively minor offense. And so there are a lot of issues surrounding the forensic process in Rhode Island. I think we benefit from having some really good people in the system. When I think of Dr. Wall, when I think of the director, the department, and A.T. Wall over at Corrections, I think we have people who are very aware of and committed to making changes. Where we have some lack of ability to do that, of course, always comes down to money and public commitment, because this is not something that comes to people's minds all that often unless they have a family member or they know of somebody who's had to go through this process. And unfortunately, that's when it first comes to most people's awareness.
Right.
So getting the public support, getting the money behind the people that are committed to these changes, I think is very important. And getting the courts on board, getting everybody comfortable, getting the prosecutors, getting the police, getting the judges comfortable with the fact that things are different and that we need to act differently.
Who makes the determination that a person needs to have a competency eval? Would that be you as a judge, or would a lawyer make that presentation to the judge and say, I really think that this person needs to be evaluated for competency?
That it could come in either direction.
Okay.
Quite often, it's the way the person behaves in court. And if you're not familiar with the symptoms of mental illness, if you're not familiar with what a person who is not competent or does not understand what's going on, they may look contemptuous. They may look like somebody who's deliberately attacking the integrity of the court, simply because their behavior is inappropriate as we define that in the context of a courtroom. So if a judge is sensitive to these things, the judge will see that the person obviously has an issue that needs to be discussed. If it's florid enough, then it becomes a question of competency. Then there'll be a determination made by the judge, usually with a recommendation or concurrence of the attorneys, that the person should be put into the forensic unit for a brief period of time for a competency determination.
Okay. Is it the law in Rhode Island that you have a number of days to regain competency before a person may be deemed either unrestorable or not guilty due to reason of insanity? Because the reason I'm asking is that I went and did a survey down in Florida of a forensic hospital, and that was their stipulation in Florida, that you had 125 days to regain competency at the forensic hospital. And if that was not able to be done, then there was a determination that they were either unrestorable or that they may be considered NGRI, not guilty due to reason of insanity. Is there something like that in Rhode Island, or no?
It is part of our general mental health statute that a person is taken to a facility for the purpose of competency restoration, and we use the forensic unit. That person can be held in custody up to, I think it's 2/3 of their sentence, their potential sentence.
Okay.
So for a misdemeanor where the potential sentence is a year, they can be in the forensic unit for up to 8 months. There are escape valves, safety valves as it were, if there's a determination made that the person cannot be restored to competency in advance of that, that the patient can petition to come back to court and be released. There need to be regular hearings and reviews. But a person can be held for quite a lengthy time in the forensic unit without going to trial, simply because they're not competent to be able to get to trial.
Okay.
And of course, the person has to be competent to stand trial, i.e. they have to be able to assist their attorneys and understand what's going on.
They have to understand the charges?
They have to be able to understand what the charges are. They have to be able to assist their attorney in the defense of those charges and to understand the nature of the proceedings that are taking place. That is different from the question of competency, of not guilty by reason of insanity, which relates not to the time of the trial, but to the time of the act.
Okay. Okay.
So at the time of the act, was the person able to understand what it is that they did? Did they have the ability to form the criminal intent? Did they understand right from wrong? If they did not, then they are not guilty of the crime.
Who determines that?
The judge or the jury, depending upon who the
Okay.
case is going to.
Okay.
So a person may have a defense of not guilty by reason of insanity, but never be able to present it because they're not competent to stand trial because they cannot assist their attorney in the defense.
Okay.
So there are two separate processes. It's two different steps. First, have the person be able to understand what's happening to them. And then second, discuss what happened at the time of the event and to whether or not at that time they truly understood it. The problem, of course, is that people drift in and out of competency.
Right.
Depending upon compliance with medication, depending upon a whole bunch of circumstances. So that one of the problems I've read about the Florida environment is that the forensic units are not close to the courts. And so a person will be in the court, be determined not competent to stand trial, trucked to the forensic unit, which might be 150, 200 miles away.
Oh, correct. Right.
Restored to competency, and then trucked back to the court, awaiting the trial. But by the time they get to the trial, they've decompensated because they're not in the forensic unit anymore.
Right.
So you wind up with people, I've read about this cycling that goes through in the Florida system because of the physical lack of proximity between the various facilities.
There were 6 forensic
Right.
units in Florida, and one of them, I think it was in Jacksonville. One of the prisons in Jacksonville had a 7-page summary of how to act mentally ill to get to the forensic unit because it was a better place to be than it was to be in prison.
Right.
So they would act
That
out.
wouldn't be true here.
It would act out. Right, there you go. But they would act out and get to the forensic unit. But then the folks that were there, that were obviously trained to work with folks, would find out pretty
Right.
quickly
Who the
that they
malingerers
were
were.
who the malingerers were, and then just send them right back to prison. But
Right.
It was unique to hear of a little treatise, a 7-page treatise on how to act crazy so that you could
Right.
get to the forensic hospital.
Right. Well, and of course, you do see a lot of people that have very obvious, very florid symptoms coming into court. But you also get a lot of people whose symptoms are far more subtle, who are not necessarily at first blush by a layperson diagnosable.
You might call that a veneer.
They may have an excellent veneer.
Yeah.
That's right. That's a good way to put it. They have an excellent capacity to appear not to have a mental illness, and coming to court, they do not appear to be different. They do not appear to have the medical condition that would justify some different treatment. But yet then later on you might find out that the person does have a problem.
Now, that would show up probably once they were incarcerated, do you think? I mean,
It could show up once they were incarcerated, or it may show up if the person is put on probation. A probation officer who has more extended contact with the individual might notice that there's something not quite within what they consider to be normal parameters with this individual, and you just miss it. So you have to worry about that.
Well, one of the other issues, too, as we had mentioned before, 16% of the folks that are at the ACI now have a serious and persistent mental illness.
Right.
And so that's about 700 and change.
Something like that.
Folks that are seriously mentally ill.
Right.
My guess would be that there's very little treatment going on for folks if again, they're quietly psychotic, quietly symptomatic, and don't present a problem within the environment, then they don't get treatment.
Right.
Would that be fair to say?
I think that's fair to say.
Okay.
That resources are scarce, and so you're always going to have those resources tilted toward the individuals that have the most immediate, pressing, and difficult problems. And so you undoubtedly have people in the system, although the ACI does try to provide treatment, the spectrum of people that they're treating is narrower, I would assume, than you would see in the general public.
Right.
Simply because of their lack of resources. And of course, once you open the door and the person removes from the prison and goes out into the community, even those limited resources that were provided, the treatment that was provided, may disappear.
People that we've been working with who are homeless, chronically homeless, come out of prison, come out with no address, come out with no skills, come out with no job, and they're expected to sort of make it.
Right.
And what do? They often will recommit a crime to get back into prison. Maybe not to get back into prison, but to get money or to provide for whatever they needed to provide for, drugs, family, whatever the issue might be. But are often hard-pressed to be able to continue to make it in the community if I can't get no one will rent to me and no one will hire me.
Right.
So it's just, again, it's a vicious cycle of
Right.
people revisiting the criminal justice system again, whether you're mentally ill or not.
Well, and I think that this is actually part of the good news, is that it seems like more and more agencies and organizations and individuals and government leaders understand that the problems are not compartmentalized, that they should not be, that the problem of homelessness and the housing issues and the mental health issues and the substance abuse issues may all be, or the anxiety issues, the post-traumatic stress disorder problems, all are part of a package that has to be dealt with in a unified way. And so that does seem to be an area where people are getting more and more understanding that you can't deliver medications to somebody's house if they're homeless.
Right, right.
You can't check on their activities of daily living if they're living underneath
Under a
an
bridge.
overpass, under a
Right.
bridge. So the fact that all of these pieces are starting to come together in some areas and with some people, I think is a positive sign. I don't mean to be negative at all. Yeah.
Well, there is plenty of work to
Right.
go around.
Oh, yeah.
And there needs to be collaboration between all of the providers in
Right.
terms of doing the work that we do.
Right.
There is another emphasis on working with the whole person also.
Right.
Because folks that come to prison, that come before you as a retired judge, not anymore, but when they came to you as a judge, they would have a co-occurring disorder. They'd have a substance abuse issue, they'd have a mental health issue. Sometimes they'd have medical issues that were, so it'd be tri-occurring, if not more.
Right.
So it'd be very difficult to kind of assess, will the real issue stand up when it's actually all of the issues?
Right.
Kind of interacting and affecting each other.
Right. And that's especially true in cases of people who are suffering from a major mental illness, who are not treated. They may be effectively self-medicating. And part of that self-medication process happens to be the utilization of illegal substances.
Right.
So you wind up with mentally ill individuals with serious substance abuse problems. And then the question becomes, how do you separate them out? Can you separate them out? How do you treat them? Which do you treat first? What is the court's responsibility? These are not simple questions for the court or for the providers. And they are, frankly, questions that sometimes courts and judges can be very uncomfortable having to deal with. Because we, in the provider community and among the professionals, it's often understood that you can only approach one thing at a time, and you have to solve one problem and then move on to the next one.
Right.
You might have to let something slide. So you might have somebody where their objective is to use less marijuana, and to tell the court that you
Harm reduction?
that you should encourage the person and congratulate them because they're using fewer illegal substances,
Right.
is not something that most judges are comfortable
Right.
having a conversation
Right,
about.
exactly.
So to on one day, on a Thursday, say, well, you're going to jail because you're using marijuana, and on Friday saying, well, I hear you're using less, that's wonderful, is something that can cause a judge a great deal of internal
Well,
conflict.
it can cause some confusion for the person before the judge, too.
Before the judge as well, yes.
Will the real issue
Right,
please stand
exactly,
up?
Exactly,
Well, we've realized years ago that there needs to be integrated treatment, that a substance abuse and a mental health issue both need to be treated as primary
Right.
diagnoses, and they need to be treated at the same time, not a sort of a pre-post notion,
Right.
because then you really don't know if we're going to wait 30 days for you to dry out
Right.
and see if you're really depressed
Right.
or
Right.
really have bipolar disorder, then we've missed something, because
Right.
most people are not going to dry out, first
Right.
of all, if they're dependent
Right.
on the chemicals. So they need to be treated in an integrated fashion.
but that's a much more complicated thing to do. And in the context of the courts, that's an added layer of complexity
Yeah.
that people can be very uncomfortable with.
Oh, I can imagine that. I can imagine that. So what we're going to do is we're going to fairly soon. I'm getting the high sign over here that we're
Okay.
going to be wrapping things up.
Okay.
But we're going to come back to you on the flip side of this, and we
Alright.
want to talk about. We've been talking about the problems of working with folks that are
Right.
mentally ill in the court system, but I want to get to some of the ideas that you have
Right.
in terms of advocacy around solutions that we can do things differently, sort of the crystal ball, or the if I could be ruler of the world, what would I do to help the mentally ill?
That's what
get
every
their
judge
needs met?
thinks.
You all think they're rulers of the world?
That's what's it,
All right.
but that's good, because so far I think people would come away very depressed.
Yeah, there you go. There you go.
So we'll
But
give them some positive
We'll get
things.
some positive in the next show.
That's
But
good.
thank you very much for being
Well,
here
thank
today
you.
and being with us on
Glad to
Mindset
be here.
Matter.
Okay, thank you.